We have drawn.
I think we would like to just address orally on the record a few things regarding that notice at the court's.
Yes, and I wanted to give the defense to respond to that on the record. Sorry, General Desmond.
Thank you. Your Honor, the notice that the state has filed, the 12D notice, that notice, I think defense counsel will agree, the parties went back and forth over the course of several days to try to develop a language that was agreeable to both parties. The reason being is I believe defense counsel is going to ask the court to put down an order that is corresponding to this 12D notice relative to the evidence. And the reason that's relevant to today's hearing, Your Honor, today's motion is regarding the defendant's request to suppress evidence, including the defendant's statements. And a portion of those defendant's statements occur on February the 13th of 2024. Now, all of the criminal conduct for which the defendant is indicted and charged with occurred on February the 8th of 2024. And it is the position of both the state and I believe the defense counsel that all the evidence, the probative evidence relative to that conduct came into existence on February 8th, 2024, with perhaps the sole exception of when the defendant was taken into custody on December the 13th of 2024. There was an attempted interview by the Tennessee. Yeah, I'm sorry, what did I say? December. My apologies. February the 13th of 2024, the Tennessee Bureau of Investigation attempted to conduct an interview with Mr. DeHart relative to what occurred on February the 8th. I say attempted because despite the fact that the interaction lasted the better part of a half hour, it never progressed past the point of Miranda. They attempted to go through the Miranda process, but the defendant never waived his Miranda rights, and as such, the Tennessee Bureau of Investigation never really asked him any questions regarding the February 8, 2024 conduct. So after very careful review, the state, after reviewing that statement multiple times, does not believe there is any probative value to that statement from February the 13th, 2024. There's nothing contained in that statement that the state thinks is probative to the conduct regarding the killing of Deputy McCowan and what else occurred on February 8th. So as such, the state has made a strategic decision that it doesn't intend to introduce in its case in chief the February 13th, 2024 interview. And as that is at least a portion of the subject matter of defense counsel's motion to suppress, the state doesn't see any need to fight about something that it doesn't plan to introduce in the first place. So what we've done is craft an order kind of reflecting the meeting of the minds and the positions of the parties here, but there's a couple important things to note that I think the court will understand. There are certainly scenarios that can arise where evidence that would not be admissible because it's not relevant or because it's been suppressed for whatever reason can later become admissible if certain things transpire, whether that be it becomes probative due to impeachment because a party opens a door, or it becomes probative in rebuttal based on evidence introduced by another party. So the state is agreeing that it is not going to introduce its the February 13th, 2024 statement in its case in chief. We're agreeing to that. We are also agreeing that if the state believes that something occurs during the trial that opens the door or causes that statement to somehow become probative in the perspective of the state, it will then approach the court and request to have a jury out hearing prior to trying to introduce any of that February 13th, 2024 evidence before a jury, that we would have a jury out hearing as to whether or not the evidence which was not to come in is now admissible for some other reason, whether that be rebuttal or impeachment evidence or anything like that. And the way we have styled this order, on February 8th, of course, the shooting on Sevierville Road takes place. And after that point, Mr. DeHart and the state has informed defense counsel the state intends to introduce evidence that Mr. DeHart fled the scene of the shooting, that he met up with two individuals, Maurice Warren and Marcus DeHart. He got in a vehicle with them. He traveled to Knoxville to the Buckethead Tavern off of Ray Mears Boulevard in Knoxville, that Mr. Warren went to the Target to purchase a burner phone, for lack of a better term, that Mr. DeHart had some conversations with friends or families there during that period. The state still plans to introduce that evidence. However, after Mr. DeHart leaves the Buckethead Tavern, he's off the grid for a moment. And a lot of things happen over the course of the next 5 days. Obviously, there's a lengthy manhunt with federal and local authorities, but none of that conduct is probative to the conduct that occurred on February 8th of 2024. So we have essentially styled an agreement that evidence arising from Mr. DeHart's actions or statements after he left the Buckethead Tavern on the night of February 8th are no longer probative, and thus the state will not be introducing that evidence in its case in chief, with a few important exceptions. The state does intend to introduce sufficient evidence to request a flight instruction, and the state has told defense counsel that we plan to introduce testimony that law enforcement was actively looking for Mr. DeHart for a period of 5 days, and that Mr. DeHart was located and apprehended at a residence in Knoxville on February the 13th of 2024. So we do plan to elicit testimony that in the state's mind, it will then use to request the court to give a flight instruction that this 5-day period occurred, and that law enforcement was actively seeking him, and it will be the state's characterization that he was trying to avoid apprehension. But as far as, specific cellular data and things from that whole 5-day window, what occurred when he was taken into custody by the Knoxville Police Department and transferred to the Blount County Sheriff's Office and brought to the Blount County Jail, all of that, none of that is probative to the conduct for which Mr. DeHart is indicted. So the state is agreeing that we don't believe that is relevant evidence and that we don't intend to introduce that evidence in our case in chief. Now, another important clarification, that doesn't mean that there isn't other evidence that happened after February 8th the state doesn't intend to introduce, such as an autopsy. The autopsy did not occur on February 8th. The state does intend to introduce evidence from the autopsy. The processing of the crime scene itself over on Sevilleville Road, much of that occurred the next day, February 9th. The processing of the Lexus vehicle that the state alleges Mr. DeHart was operating does not occur in full until the next couple of days. So and that is contained within this order, that there is evidence that occurred after February 8th that the state intends to introduce. But basically, testimonial evidence, statements made by Mr. DeHart, actions of Mr. DeHart after he leaves that Buckethead Tavern on February the 8th are not probative to the conduct in which Mr. DeHart is indicted, unless something occurs to open the door or cause it to be appropriate rebuttal evidence or anything like that. And then we have a jury out hearing wherein the parties can state their positions as to whether or not it is then appropriate to come in. So that is the meeting of the minds that the parties have reached, and I certainly...
Can I see the order?
Yes.
And Judge, I think he's misspeaking. We don't have an order, we just have the notice, the 12D notice.
Oh, okay.
Okay. It is a notice the state has filed that the parties have worked
I
through.
have this. I thought that you were...
Yeah, I'm sorry.
...proffering a proposed order.
I believe it will be Mr. Johnson's request, though, that the court put down an order that comports with the spirit of this notice. Is that
I'm
correct?
happy to draft one and submit it to the court as proposed order.
So based upon that, then, Mr. Johnson, on behalf of the defendant, did you hear the statements made by General Desmond?
I did. I have just a little bit to add,
Okay.
Your Honor. And, I mean, this was a point of discussion, and when we had the preliminary hearing following remand, this was an issue as well because we raised the total of the suppression issues, not as exhaustively, but we had raised those with the General Sessions Court on remand as well. And down there, we came to an agreement that in order to limit the scope of the suppression hearing, that the state would not seek to introduce certain evidence beyond February 8th of 2024. And so here, as we were gearing up for this hearing, there were those discussions between us and the state. As the court's aware, there's a lot of evidence in this case. There's a voluminous amount of discovery. When you're dealing with suppression issues, it's one of the reasons why Rule 12D exists, so we can try to ascertain what the state's really going to try to introduce. And so in the course of those discussions, we came to this sort of understanding. And the only thing I have to add, Judge, is just under the plain language of the 12D notice the state has filed, while our suppression motion is expansive, it covers several items of evidence in several locations. It's our understanding, based on the 12D notice, the scope of our suppression motion now is just going to be dealing with the events that occurred on February 8th, 2024. And in the plain language of the notice at page 1 and page 2, I think that first paragraph that goes through and it says, and I'll start with therefore, the state hereby provides notice that it does not intend to introduce any statements made by the defendant on February 13th, 2024 in its case in chief. Furthermore, during its case in chief, the state will not introduce evidence, testimonial or otherwise, that was obtained by law enforcement from Mr. DeHart, notwithstanding whether it was later processed or examined. I think that gets to what General Desmond was talking about concerning, the vehicle, for example, was processed later, but it was obtained obviously on February 8th or later. The state will introduce evidence that law enforcement actively searched for Mr. DeHart from February 8th through February 13th, when Mr. DeHart was ultimately arrested in Knoxville, and then I believe the last few sentences are specific, for example, making certain that the state's notice doesn't somehow be construed to exclude those particular items of evidence. I'll draft an order, a proposed order incorporating that language, Judge, but I think what that does is, in effect, significantly narrow the scope of what we're doing today.
The court had planned to address the notice as part of the order based on the issues that are being presented today. However, this is negotiated, and you all understand the parameters in detail. I would request them to agree to order also.
We will, Your Honor. And it'll mirror the language that's already in the notice.
I have no doubt that Mr. Johnson will draft a submission order. I would like the opportunity to review and sign it.
Yeah, I'll send it to counsel for the state first.
The court still intends to address the issue in as much as this is a motion to suppress a variety of different avenues. And so I will address it, just that this was not litigated today based upon your agreement, and then you can submit it in the order later.
Yes, sure. Thank you.
All right, that being said then, Mr. Johnson, are you ready to proceed on your motion?
I am, Your Honor. I believe that, I don't think it's disputed that this was a warrantless seizure of Mr. DeHart on February 8th, 2024, and as such, the state has the burden of proving an exception to the warrant requirement. And so we would ask, unless there's some sort of dispute about Mr. DeHart's standing as to the vehicle, and so we would, I believe, the state's prepared to offer some proof on that issue.
And so by way of any opening remarks, is that you have well briefed the issue and well pled the issue. I wanted to give you the opportunity to want to say anything further as far as opening before we get to the proof.
Very briefly, Your Honor, I mean, the issues for the court, we have raised that there were a number of illegal seizures here of Mr. DeHart, and so what we're going to attempt to do today through the examination of Deputy Eggers is to break down the interaction between her and Deputy McCowan and Mr. DeHart. One of the more significant issues, if not the most significant issue here, ultimately is the issue as to whether or not there was excessive force as to Mr. DeHart, which would constitute, as the court's aware, an illegal seizure under the Fourth Amendment. And we have cited a number of cases. The state has dealt with some of those in its response concerning whether or not this was excessive force, whether or not to subject Mr. DeHart, who refused to get out of a parked vehicle, at that moment was not driving away, at that moment was, before there was physical
What occurred when you decided to try to forcefully remove Mr. DeHart from the vehicle?
Yes, I stepped forward and opened the door. He tried to shut the door. Deputy McCown and I both pulled it back open. And he had a seatbelt on, it was still buckled in. So I reached across, I put my right arm kind of across his chest area, keeping from bending forward over the seatbelt, and reached in with my left hand to attempt to unbuckle the seatbelt. At that point, I would describe it as maybe like a tussle. He was kind of swatting me away, trying to push my hands away to keep me from unbuckling. I do believe that I may have struck him trying to move his hands away. He may have struck me. I don't know exactly if anybody was hit harder or not, but it was more of just a struggle of him trying to push me away and me trying to get the seatbelt unbuckled.
Were you able to successfully unbuckle his seatbelt?
No.
What did you do after this tussle and your not being successful in unbuckling a seatbelt?
While I was doing that, Deputy McCown suggested tasing him, and so I took a step back so that Deputy McCown could do that effectively. Once I took a step back, Deputy McCown drew his taser and he started giving Mr. DeHart commands.
Did you and Deputy McCown give Mr. DeHart any verbal warnings relative to the taser?
Yes, I believe we both told him that he didn't step out of the car, he was going to be tased.
And how did he respond to those warnings?
Still non-compliant, said that he wasn't going to step out of the car.
Ultimately, was a taser deployed that you saw?
Yes.
All right, can you describe to the court what you observed when the taser was deployed?
I think I described this last time, but there were a total of technically 4 deployments, but the first deployment that I'll explain was ineffective. So the Taser 7 that Deputy McCown was using has 2 sets of probes. The first set of probes, I don't know if maybe one of them didn't connect or didn't go into the car. I'm not sure, but the first round that he fired out of the taser was ineffective. So he fired his second set of probes. This was
What did the defendant do did you see the defendant do anything after the first set of probes was fired that were ineffective?
I saw him move. I don't know if he was able to swat a probe away or if the probe I don't know if the probe made contact or not. So I don't know if he was able to swat a probe away or swat the wire out, pull it out. I'm not exactly sure, but technically the first deployment was ineffective. Immediately thereafter, Deputy McCown deployed the second set of probes, and then the taser was effective.
Now, you say the taser was effective. What leads you to conclude that the taser was effective?
Mr. DeHart yelled, and he I describe it as locked up. The technical term for it, I'm not an expert, but the technical term for it is neuromuscular incapacitation, and that's what he exhibited signs of.
Now, is that something that you received information on in the academy?
Yes.
Prior to February 8th, had you deployed your taser or seen people tased in the line of duty?
Yes.
Okay, and you had witnessed that sort of behavior in reaction to a taser before?
Yes.
Okay.
I did that when I got tased.
All right. So what occurs, the second set of probes is fired and there's an effective contact. What occurs at that point in time?
We continued giving Mr. DeHart commands to step out of the car. Once the 5-second cycle was over, I told Mr. DeHart if he did not step out of the car, he was going to be tased again. I believe Deputy McCown did as well. And he still refused to step out of the car, so he was tased again.
And is it always a 5-second cycle?
Yes.
Okay. And after the second cycle, 5-second cycle, I guess the third deployment, what occurred from that point in time?
So during that second cycle, I attempted to, they always say kind of overpower is how they teach it, but I attempted to unbuckle Mr. DeHart while he was incapacitated by the taser, so he couldn't fight back. When I did that, when I put my arm across to unbuckle the seatbelt, I somehow put my arm in and it got wrapped up in the wire, so I was being tased as well.
And how long were you tased for, do you know?
Probably 3 to 4 seconds.
And what did you do when you got caught up in the taser wires and felt the effect of the taser?
I also locked up.
After the cycle ended, what did you do at that point in time?
took a step back, pulled my arm out of the wires, kind of shook my arm off, with the intention to go back in.
All right. Silly question, but were you able to unbuckle the seatbelt while you were in there and he was incapacitated at this time you got caught up? All right. So you backed out of the vehicle after being tased. What occurs next?
Just about as soon as I backed out, Mr. DeHart pulled the door shut, and then I was shot, Deputy Cowan was shot.
All right. Was the fourth cycle, describe the fourth cycle, or I guess the fourth deployment, the fourth deployment of the taser. We've had the third deployment where you've been tased. What happens during the fourth deployment?
That was when he was able to fire
Okay,
the rounds.
gotcha. Where were you struck?
In my right leg.
And what did you do after you were struck?
I just felt a lot of pain. I didn't know exactly where I was hit. It kind of turned me around away from him, knocked me off my feet. So I had my back to him. I was on my stomach on the ground. I attempted to get up. I couldn't really see what was going on. Still hear shots being fired. I did not know if it was Mr. DeHart or Deputy Cowan. I'm sorry.
You're fine, take your time. Were you eventually able to get up off the ground?
Yes,
Where did you go when you were able to stand up?
behind Deputy Cowan's vehicle.
And were you able to see where Mr. DeHart was at this point in time?
Yes, he was still in the vehicle. I got behind Deputy Cowan's vehicle for cover, radio that shots had been fired and I've been hit. At that point, I did not know about Deputy Cowan yet. Drew my weapon. I could see that Mr. DeHart was still in the driver's seat of the vehicle. And I attempted to return fire. My intention was to return fire. I saw that there was a house directly in front of Mr. DeHart's vehicle, so in the background where my shots would be going. There were lights on, there was a car on the driveway, and I did not feel comfortable returning fire at that point because I didn't know if anybody was inside the house. At that point, I was also able to observe Deputy Cowan laying on the ground next to the car.
Did the Lexus eventually move from the position it was in to a location where the residence was not in the line of fire?
Object to leading.
Did the residence, withdrawn, did the vehicle move from its position?
Yes.
Can you describe to the court what you observed when the vehicle moved and what you did?
The vehicle was driving back towards the River Road, on the left side of Deputy Cowan's car, and I was able to return fire then.
Can you describe to the court what you're observing when you're returning fire? What are you shooting at?
Mr. DeHart,
All right. Do you know how many rounds you fired?
3.
And do you know if you struck the Lexus?
I believe 2 rounds struck the Lexus. My 3rd round struck the A-pillar of Deputy Cowan's car.
What did the Lexus do after you returned fire?
Took a right on the Civil Road and continued back to the stand.
What did you do at that point in time?
I knew that I was hit and I was going to need, I didn't know if I needed to pack a wind or apply a tourniquet. The quickest thing was going to be to apply the tourniquet to provide aid to Deputy McCowan. So I reholstered my weapon, pulled out my tourniquet, and I actually had help from a bystander to apply that.
Were you able to get the tourniquet on?
Yes.
What did you do after you applied the tourniquet?
I attempted to go to Deputy McCowan and provide medical aid to him.
Did you utilize your radio at any point in time after that?
Yes.
What did you say on the radio?
I informed dispatch that, shots were fired, that I was hit, and Deputy McCown was hit, and then, once I got the tourniquet on, I was attempting to walk to him. I informed dispatch that I had a tourniquet applied, and that Deputy McCown was down, and I couldn't get to him.
Did other members of the Blount County Sheriff's Office respond to the scene?
Yes.
What happened with you once they arrived?
Deputy Seth Bloodgood arrived and was able to get me into the back of his car, fix my tourniquet because it wasn't on tight enough, and transport me to UT Medical Center.
And just very briefly, can you describe the injuries you sustained as a result of this shooting?
A gunshot wound in the right leg.
These have already been entered into evidence, but just for the sake of the record, were you wearing a body cam video that evening?
Yes.
And is there any audio or surveillance equipment on your cruiser?
Yes.
Do you know if your audio and surveillance equipment was able to capture the events of February 8th, 2024?
Yes.
And have you reviewed those videos previously?
Yes.
And are they a fair and accurate representation of the events that you've described here on the stand?
Yes.
One moment, please, Your Honor. Just very briefly, if we can return to before the traffic stop. You articulated what you observed regarding the Lexus SUV. Did you notice anything that in the roadway or any debris that would have caused that sort of action?
No.
All right. And at any point in time, while you were behind the Lexus SUV, did you observe the Lexus utilize any of its turn signals?
No. I don't believe so.
Good. Yeah. Pass the witness, Your Honor.
Mr. Johnson?
Yes, Your Honor.
I am, Your Honor. I got here early, so we could do that. Deputy Eggers, good morning. As you know, I'm Stephen Ross Johnson. We've met before at the preliminary hearing, right?
Yes, sir.
And let me ask you, you mentioned during a direct examination toward the end, you were asked questions by General Desmond about your review of your cruiser video and dash cam video, or your body camera video and your dash cam video. Do you recall that?
Yes.
And you reviewed those part of this hearing today?
Yes.
And let me talk about your preparation for this hearing a little bit. Did you meet with members of the DA's office to prepare your testimony today? And how many times?
Twice.
Twice? How recently?
Once yesterday, once on April 30th.
Were you given your prior preliminary hearing testimony to review?
Yes.
Both preliminary hearings?
The most recent one I reviewed.
The one where I was counsel for Mr. DeHart.
Yes, sir. Yeah.
And did you review your interviews with the TBI
Yes.
to include the interview that occurred roughly a week after February 8th, 2024?
The one that occurred on, I believe, February 15th. Yes.
Yes. Exactly a week then, right? Okay. These meetings that you had with the DA's office, do you know, did you go over your testimony and your recollections from February 8th, 2024?
Yes.
Do you know whether or not those were recorded?
I don't know
Do you know if there were any notes taken?
I'm not sure. I did not take any notes, but I'm not sure about any of those.
Did you review any other materials other than the ones we just discussed to prepare for your testimony today?
I do not believe so.
Did you review the Blount County Sheriff's Office use of force policy?
I have reviewed it, yes.
Did you review it prior to your testimony today?
Yes.
How recent was that review?
This last week,
This past week?
yes.
Can I approach the witness, Your Honor?
Your Honor, I guess I'm going to object at this point in time. I don't believe he can, if he wants to lay a foundation to enter the use of force policy, that's one thing, but I don't see, she's not been asked any questions about the use of force policy. It seems as if he's trying to use the use of force policy to somehow impeach her. I think the proper procedure to impeach would be to ask her about it, and then if he feels she says something inconsistent with the policy, then there might be a mechanism to go forward, but I'm not sure how the relevance of the use of force policy at this point in time.
I'm not asked to do anything yet. I'm not asked to introduce it yet. Just asked her.
I believe there's a question of has she reviewed it, and she said yes. And with the answer is we can get.
Yes, ma'am.
So at this point, I'll note your objection. I think it's a bit premature. I'm gonna allow him to ask the foundation questions, but I'll table it for this moment.
Can I approach Judge? I have copies for you too of things. And
I don't look at the copies until they're actually part of their
Okay.
evidence.
Then I will hand them up. So can you take a look at what I just handed you? And if we could, I believe, let's mark that for ID. Just at this time, I believe it's Exhibit
ID 2.
2. Judge Jones, continue to lead to approach.
Yes.
Thank you. Deputy Eckers, you have up there on the stand with you what's marked for ID right now is Exhibit 2, or for identifications, Exhibit 2. Do you recognize that document?
Yes.
Is that the use of force policy for the Blount County Sheriff's Office?
Yes.
Is that the use of force policy that you reviewed in preparation for your testimony here today?
It looks like this one is probably the one from 2024, but yes, it's close. There may be some amends or some new language in it, but I believe this is the same one.
Well, let me ask you, you believe it's the same one. Do you have any reason to believe that the one you reviewed within the past week in preparation for your hearing today is different than the one that I just provided to you?
I don't believe so.
And one additional question, and I'm sorry to backtrack a bit. When I was asking you about those things that you reviewed in the course of preparing for your testimony here today, I believe you testified on direct examination that you called, when you initiated the traffic stop with Mr. DeHart, that you called Deputy McCowan. Is that right?
Not when I initiated, but after I had just talked with him, yes, I did call.
Yeah, poorly formed question on my part. So let me fix it.
Okay.
Okay. So at some point in time during your interaction with Mr. DeHart, after you were back in your cruiser,
Yes.
in your vehicle, this would have been after the third interaction with Mr. DeHart,
Yes,
right?
correct.
Okay. You were in your vehicle and you called Deputy McCowan using your cell phone, right?
Yes,
Was it your personal cell phone?
it was.
Have you been asked to preserve your cell phone?
Yes. Well, I'm not sure exactly what you mean by preserve, but I'll tell you what they did. The TBI did use my phone number and pull my phone records, if that's what you're asking.
Sure. I'm just asking, what you were preserved. So the TBI pulled your phone records for your personal cell phone. Is that right?
Yes.
And did anyone obtain your personal cell phone itself?
No.
Was there any sort of image done of your personal cell phone? You know what I mean by image?
No.
A forensic copy.
I'm not sure what.
You're not
I'm
sure?
what the TBI did. I know that they obtained my cell phone number, pulled my phone records, but I'm not sure the extent of what they did.
Did they ever have your cell phone?
My phone was on the scene while I was at the hospital, so I'm not sure if they did anything there.
And do you still have that same phone?
No, I have a different phone.
What'd you do with the phone?
I traded it in for a new phone.
You traded it in for a new phone. So you traded it in at the phone company?
Yes. Verizon, to be specific.
Thank you. So Nat, thank you for that. Let's go back now to this use of force policy.
Okay.
So if you could go with me to, I believe it's at page 1. You see page 1 there?
Yes.
You see policy A?
Yes.
And does it correctly state that deputies are authorized to use that force which is objectively reasonable under the circumstances known to the deputy to enable him or her to defend others, defend himself, herself, or to effectuate a stop or arrest, right?
Yes.
And deputies are authorized to use only the amount of force necessary to accomplish lawful objectives, is that right?
Yes.
And apply de-escalation techniques when possible, is that right?
Yes.
Okay. And it cites a case there, Graham versus Connor. Do you see that?
Yes.
Is that something that you learned in the academy?
Yes.
And so you were taught this standard? Is that right?
Yes.
And once again, you said this is something that you reviewed in preparing for your testimony here today?
Yes.
And you recall that this policy also has some information in it about the utilization of tasers,
Yes.
and that tasers are dangerous,
They're considered less than lethal force.
less than lethal force. But you recall from your training at the academy, you were trained on tasers, weren't you?
Yes.
And in fact, you had to take a test about tasers. Do you recall that?
Yes.
And in taking that test about tasers, you learned that tasers can kill people, right?
They're less than lethal, but there have been cases, yes.
There have been cases, yes. And I believe you said on direct examination, when you described the phrase locked up, what was the phrase that you used when you described what locked up meant when you were getting tased?
Neuromuscular incapacitation.
Neuromuscular incapacitation. Is it your understanding from your training that you're electrocuting someone and affecting the signals going from their brain to their muscles, right?
Yes. That would be, yeah, that would be a good description.
All right. And that part of your training from the academy, and I think it was even part of your test at the academy, is that tasers can cause people to have heart failure, right?
I'm not an expert on a taser, but I guess it could if there are prior conditions.
Well, do you recall that? I was asking, not asking if you were an expert, I'm just saying, do you recall that from your training?
Not heart failure specifically, but medical issues, yes. If there are, I do not recall heart failure specifically. If there are medical issues present prior to the tasing, then yes, the tasing could affect some type of medical issue.
Do you recall being trained about how the application of a taser can affect the heart?
I think generally, from what I recall, was just generally if someone has a present medical condition, including heart, nerve, things of that nature. I don't remember specifics about the heart specifically.
Obviously, going into this interaction with Mr. DeHart, you were aware that he was a larger man, right?
Yes.
And is overweight, right?
Sure.
That's one of the reasons why you had difficulty, among others, just reaching around him to get his seatbelt off. Is that right?
Yes.
His stomach was covering the seatbelt.
Oh, it's more that there was active resistance, yes.
Well, yeah, I'm talking about his body right now. I said one of the reasons, right?
Yes.
Okay. So, but his stomach was covering the seatbelt, correct?
I believe so, yes.
All right. And is it fair to say, just based on your knowledge, that people that are middle-aged and overweight, they can have heart issues, right?
I'm going to object to this witness's foundation of knowledge of whether overweight people have heart issues or not. All sorts of people have heart issues. Skinny people die of heart attacks all the time.
Mr. Johnson, your response?
I just asked her based on her knowledge as an officer interacting with people, and she said that you don't know whether or not a taser is going to have a lethal effect on someone because you don't know if they have heart issues or not. And so I'm inquiring about, did she know anything about Mr. DeHart's heart issues?
I think that wasn't the question. You can ask if she knows about whether or not Mr. DeHart had any heart issues. But as far as the other questions, she's already answered as far as your training.
All right, I'll ask. Did you ask at any time Mr. DeHart if he had any medical conditions or heart issues? Did you ask him if he had any neurological issues?
No.
You just were able to observe that he was middle-aged and overweight, right?
Yes.
All right. I'm going to move Exhibit 2, which is ID at this time, into evidence.
Response?
I would object to relevance as to how the use of force policy has anything to do with whether this is an unconstitutional seizure that should result in suppression of evidence.
Mr. Johnson?
Part of the issue here is obviously what her training was concerning use of force, and I asked her if her training was consistent with that use of force policy, and she said yes, and then she also said that it is a policy that she reviewed prior to her testimony here today, which is going to cover the force that was utilized as to Mr. DeHart. And so I think that for purposes of a suppression hearing where use of force issues are at issue by the officers that interacted with Mr. DeHart, I think that it is relevant for purposes of this hearing.
All right, based upon the witness's answers to the questions, I'm going to admit it as an exhibit. I'll note your objection to the record, General, and that doesn't mean it necessarily should wait, but I do think it is relevant.
Thank you.
All right.
Exhibit 2.
Deputy Editors, now let me ask you some questions about just kind of your background and your experience as an officer, okay? And at the time of your interaction with Mr. DeHart on February 8th of 2024, were you 22 years old?
Yes.
And other than your training at the academy at the Blount County, with the Blount County Sheriff's Office, did you have any other training on excessive force, search and seizure, things like that?
There were other trainings included at the academy on those topics.
On those topics?
And
But-
I had also, I've worked here since I was 18, so I started at the jail at 18. So I've been through a corrections academy with the jail, and then subsequently been through several in-services and training while I worked in adult corrections.
All right. So you just got to my next question. I was going to ask you, when did you start with the Blount County Sheriff's Office? So you were 18 years old,
Yes, sir.
and your first job was working in the jail?
Yes, sir.
How long did you work in the jail?
Almost 3.5 years, close to 3 years.
And I believe, if I wrote this down correctly, you were in the academy at, is it 2022, is that correct? And I believe August to November of 2022?
Yes, sir.
And right after you got out of the academy, what's the first job that you had?
Patrol deputy on it, that I was on FTO, so training on the road.
Yeah, explain the acronym for me. What's FTO mean?
Oh, I'm sorry, it's field training,
Field training?
yes. We call it FTO, you're with an FTO, a field training officer, but it's the FTO program is what they call it.
All right. So in just a little over a year prior to this interaction with Mr. DeHart, you get out of the academy in November. Was it late November or mid-November?
Late November, I can't remember the exact date. Though.
Late November of 2022. And then you go into field training where you're on patrol, but you've got another officer who's training you. Is that right?
Yes.
How long did that process last? How long did you have another officer with you?
Just over 3 months.
Over 3 months?
Yes.
And so that would have been roughly February of 2023 when you started out on patrol by yourself. Is that right?
Yeah, that's close.
And so this incident with Mr. DeHart, you'd been on patrol by yourself for roughly a year at that point. Is that
Yes.
right? Okay. And I believe you said on direct examination, your current position, you're a K-9 officer, K-9
Yes.
handler? And when did you start in that position?
March of 2024.
I'm sorry, I didn't hear you.
March of 2024.
Sorry about that. The rain outside.
Well, I moved that over for the paperwork, but I'll move it back.
Well, that's okay. Also, the rain outside is
Gotcha.
impacted my ear a little bit. In your interactions, your other stops, vehicle stops, you had occasion to pull persons over and ask for consent to search a vehicle, right? And here, at no point in time did you ask for Mr. DeHart's consent to search the vehicle, did you?
No, I asked him to step out of the vehicle because of vehicle circumstances.
Right, and you asked him to step out of the vehicle during the fourth interaction with him. Is that fair?
Yes.
And we'll get to that. But at no point in time did you tell him to step out of the vehicle so you could do a field sobriety examination, did you?
No.
At no time did you tell him to step out of the vehicle so you could do a pat down for officer safety, did you?
No.
You didn't tell him to step out of the vehicle until after this fourth interaction with him where you are on the passenger side of his vehicle. Is that right?
Yes.
And you first say that because you smell marijuana, you have probable cause to search, right?
Yes.
Correct? And only after you say that do you say, because I have probable cause to search, you need to get out of the vehicle, right?
Yes.
And Mr. DeHart said, I don't consent to searching my car, right?
Yes.
What was your training? Because you described just a moment ago that there are times that you will ask persons to, for their consent to search their car, right?
Yes.
Correct? And so what's your training on when you ask for consent and when you don't?
I'm going to object to relevance, Your Honor. There is no consensual search alleged in this particular case. That's not part of the subject matter of this particular issue before the court. I don't know why walking the officer through consensual encounters when that's not an issue before the court would be relevant to this particular proceeding.
How is that relevant?
Her interactions with Mr. DeHart in total, in particular here on what she's explaining to him at the time and her explanation for why he has to get out of the vehicle, and it's to search the vehicle. And the consensual issues here, I believe, are relevant and are important, Judge. She doesn't tell him to get out of the car because she suspects him of DUI. And in fact, and I'm going to get into some of those questions here in a moment, she tells him to get out of the car because I smell weed. I've got probable cause to search. Get out of the car so I can search the car. That's what the stated basis was.
And that's what's relevant, Mr. Johnson. What actually happened is relevant for the purposes of the motion to suppress under allegation of constitutional violations. So the what-ifs and the maybes are simply not relevant to the inquiry here today. It's what happened.
It is what happened. What I'm getting at, Judge, is why. Why she did not ask him to consent. And I can ask it that directly.
I mean, I'll let you rephrase, but the court's ruled on the objection.
Thank you, Your Honor. Why didn't you ask him to consent?
When I asked Mr. DeHart to step out of the vehicle, he immediately refused to step out of the vehicle. Asked me why, explained to him why I needed him to step out. Typically, when people step out, I would ask for their consent, but we did not get to that.
You didn't get to that point. Typically, when you ask people to step out, you don't already tell them, though, that you've got probable cause to search the vehicle, right? Why would you need their consent?
Typically, they don't ask them why. Typically, they comply. You know, I'll say, hey, this is, I tell people straight up what's going on. That's just my practice. So I probably would have let him know, look, I smell weed in the car. Is there weed in the car? Do you have anything on you? Just be honest with me. That's probably how it would have gone, but it did not go that way.
Now, you're talking about that's probably how it would have gone if he were out of the vehicle at that point, right?
Yes.
Okay. So let's go back to that interaction with Mr. DeHart. And I want to, I know you covered some of this in direct, but let me break it down. So let me take a step back, okay? So on the evening of February 8th of 2024, you ended up behind Mr. DeHart, and is that on Sevierville Road? Is that the name of the road? Okay. And were you on closer to the Sevier County, close to Sevier County at that point in time?
Yes.
And it's a country road, isn't it?
Yes.
There's not a lot of businesses and houses out there. Is that right?
Quite a few houses, but not a lot of businesses.
Not a lot of
On
businesses.
that end.
So poorly phrased by me. Not a lot of lights. Is that a better way to say that on that road?
Depends on where you're at. Right around Burnett Station, it's lit up pretty good. There are several light poles going through there, but on down the road, in between there and town, it gets a little darker.
Gets a little darker. And where you pulled Mr. DeHart over, that's in the darker area. Is that right?
Once he stopped, yes. When I first got behind him, it was, I don't want to say well lit, because it was dark and it was nighttime, but there were street lights. It was pretty well lit until the location where he stopped.
And I believe that evening there were more deputies than usual working that day because it was a training day. Is that right?
Yes.
And I believe you explained before at the preliminary hearing that when there's a training day, you'll have everyone that's assigned to patrol will work. Is that right?
Yes.
Okay.
Unless they're on a special team or at training.
Okay. And I believe you said you had 2 county-wide backups that day. Is that correct?
Yes.
And
From what I recall, I believe there were only 2.
and you said one was Deputy McCowan, correct?
Yes.
Was the other one a Noah Payne?
Yes.
And before you called Deputy McCowan, let me go back to when you're following Mr. DeHart on the road. As you're following him on the road, I believe you said that you estimated that you saw him between 4 and 6 times his driver's side tires touch the center line. Is that correct?
The first time I witnessed his driver's side tires touch the center line, several other times he crossed over into the other lane. More
And-
so than just tires touching, he crossed over into the other lane. The video would accurately represent it, probably a lot better than I could explain it, but
All right. And the video's in evidence, and you've reviewed the video, right?
yes.
And at no point in time does Mr. DeHart fully get into the left-hand lane, does he?
I believe his passenger side tires were touching the double yellow line. One of the last times he crossed over before I stopped him. I believe so. Like I said, the video will accurately represent it.
Okay, you'll defer to the video about that,
Yes.
correct? And I believe from looking at the video, in the first 30 seconds, there is one vehicle that is in the opposite lane of travel from Mr. DeHart. Do you recall that?
Yes.
And at no point in time does he swerve in front of that vehicle, does he?
No, when the headlights of that vehicle start approaching, he swerves back over completely So I believe his tires, I can't remember if I can't remember exactly where that vehicle was, if that was when he was over in the other lane, or if that was when his tires were touching, but either way, I do remember him kind of almost jerking the car back over, it looked like.
And in the second 30 seconds of the video, there's another car traveling in the opposite lane. Do you recall that?
Yes.
And at no point in time does he get into that lane and somehow cause danger to that vehicle as it's passing.
No, the only time that he was, when I say completely in the other lane, I mean like tires touching the double yellow. The only time that he was completely in the other lane is when cars weren't approaching.
Cars were not approaching.
Yeah, he was able to jerk it back over and get back in his lane and kill the cars approaching.
All right. And at that stretch of roadway, and you can see this on your video, at some point in time, sometimes there are double yellow center markings, is that right, in the road?
Yes,
Sometimes there are broken yellow center markings in the road, is that right?
yes,
And sometimes there's gaps in the markings at intersections. Is that
Yes.
fair? And the roadway has a lot of curves in it, is that correct?
yes. That particular stretch, where I traveled behind Mr. DeHart, I think there were 2 curves. Again, video, but
And there are non-illegal reasons why someone may swerve in the road. You'd agree with me, wouldn't you?
sure.
That don't have to do with DUI, right? One would be distracted driving, right?
Yes, sorry.
And distracted driving from all the screens and phones and everything else that could be in a car, correct?
Yes,
And also, Mr. DeHart gave you a reason for the swerving in the road, and it was distracted driving, wasn't it?
yes,
Putting his hair up,
yes.
correct? He also told you he was tired, right?
Yes,
And that he had some sort of issue with his leg. Do you recall that?
I believe he said that he had had knee surgery recently.
And in fact, while you were following Mr. DeHart, and you may or may not remember this from looking at the video, but do you recall that you and your patrol vehicle on this narrow road at one point in time get over to the far right-hand shoulder while you're following him in the roadway, and you end up, it makes the rumble noise from where you're driving over that line.
Yes,
And that just happened while you were following him, right?
yes,
Once you activated your emergency equipment, your blue lights, as to Mr. DeHart, he responded, he slowed down, didn't he?
yes,
And his brake lights came on, right?
yes.
And you talked about this a little bit on direct, but I want to talk about it a little bit more. That road, it has no shoulder, correct?
Parts of it, but not the part where we're on.
Not the part you were on.
Yeah.
I'll rephrase that question to make it more artful. The part of the road that you were on at that point in time had no shoulder, right? And in fact, not only did it have no shoulder, but it drops down into a ditch, right?
Yes,
And so if you pulled all the way off the side of the road, your car would go down into a ditch, correct?
yes,
And that part of the roadway where you had pulled over, Mr. DeHart, there was a house a little bit in front of Mr. DeHart at that point, correct?
yes,
On the right-hand side of the road.
yes.
And the driveway was not paved, was it?
No,
It was sort of a grass kind of driveway, right? Was it gravel?
I believe so.
And so in your first interaction with Mr. DeHart, when you had him pull, when you approached his vehicle after he had just kind of stopped in the side of the road, and any driver that stops right there, if you looked over, you'd be able to see, I can't get off the side of the road where I'm going to fall into a ditch, right?
Right,
In my car,
Yes.
correct? And so you stop Mr. DeHart, and at that point in time, you get out and you approach the driver's side of his vehicle, correct?
yes,
And he rolls his window down, doesn't he?
yes,
And he rolls his window down all the way, doesn't he?
yes.
He doesn't just crack it, does he? He rolls it down all the way, and you ask him, hey, if you don't mind, go ahead and pull up into the driveway ahead, right?
Yes,
And he says, okay, I'll do that, right?
yes,
And then he goes ahead and he drives forward while you're getting back into your patrol vehicle, right?
yes,
And he drives forward and he pulls into the driveway of the home off of the road, and now his vehicle is completely off the driveway, but there's no way for you to get into the driveway. Is that correct?
yes,
And so you get out and you approach him again, right?
yes.
Is that right? And at that time, when you approach him, once again, he rolls his window down all the way, doesn't he?
Yes,
And he rolls his window down all the way at that point in time. And once again, you say, hey, go ahead and keep on driving into that driveway just like you were going to go to their house, okay?
yes,
And did he comply with that?
yes,
And so while he's doing that, you got back in your patrol vehicle and you followed him up into the driveway, right?
yes,
And at that point in time, then, you positioned your patrol vehicle behind his vehicle in the driveway, right?
yes.
During those first two interactions with Mr. DeHart, both of them that were on the road,
Yes,
his window was completely down, correct?
yes.
And you did not smell marijuana, did you?
I did not notice that.
And now, let's talk about the third interaction,
Okay.
all right? So with this third interaction with Mr. DeHart, while he's pulled off into the gravel, kind of grassy driveway of this house, you approach him at that time, correct?
Yes,
And in fact, do you radio ahead before you approach him for the third time and say that you've pulled someone over for suspected DUI?
no,
When did you radio that?
I did not radio that.
What did you radio?
I radioed that I was making a traffic stop, and then the rest of my radio transmissions up until the point of, we'll say the point of non-compliance was, just that I was code 4, okay. I believe, I obviously corresponded with dispatch for warrant checks, and then, Deputy McCown asked me if I was gonna need another unit, and I told him that I was code 4 McCown, and that was what I referred to earlier.
Right. And so what I'm trying to do, let me try to break this down a little bit, okay? Prior to approaching Mr. DeHart's vehicle for the third time now, this third interaction when he's in the driveway, what do you recall having radioed ahead at that time to let dispatch know?
I recall, calling out the traffic stop that I would advise him, that I was on Severe Road, and I would advise him of, across the street once I stopped. I can't remember the exact addresses, the numerics of the addresses that I gave them, but I told them where we were pulling into. I believe it was 4959, or maybe 4951, one of the two. And then I told them that first I told them we were stopping in the roadway, and then I told them I was code 4, and while he was repositioning his vehicle, I said, we're pulling into the driveway of whatever that address was. I'm sure you probably have it. And then I radioed back to dispatch again and said, never mind, we're still on the roadway, because that was the second time to pull over, like we were talking about just a minute ago. So I radioed that. Then once he was stopped in the driveway and my vehicle was behind him on the third stop, we'll call it, I informed him, I believe that we were in the driveway of 4959.
You recall radioing the vehicle tag in for them to do a check on it? And I believe you said this, but each of those times, did you let dispatch know that you were code 4?
Yes,
And code 4 means you're okay, right?
yes. I radioed the vehicle tag in when I called out the traffic stop condition.
So this third interaction, while you're interacting with Mr. DeHart in the driveway, you're beside the driver's side of his vehicle, and he has the window rolled all the way down, right?
Yes,
And you're talking with him, and there is a fair amount of debris in the car. Is that fair to say?
Sure, yeah.
In fact, there was like a cookie box sitting on the sort of on the dash of the car, right above the steering wheel.
Yep,
And you asked him about the crumble cookies,
I did.
and you recall asking him, where are you going? What you've been doing? You recall that?
Yes,
And he started answering your question, right?
yes,
He told you that he had been over at, and he also told him, you've been, I saw you weaving in the road there, and then he started answering those questions. He said, I'm putting my hair up. He's got dreads, right? Long hair. Is that fair?
yes,
And he told you he was putting his hair up, and then he starts responding to the questions about where you're going. He says he's tired, right?
yes,
And that he's driving back from his son's basketball game in Gatlinburg, right?
yes,
And then he told you that he also stopped by his grandmother's home in Sevier County just to check on it because there were some renovations being done to it. You recall
Yes.
that? You recall that?
yes,
And in fact, he even takes his phone and starts showing you pictures of where he went by that house and was doing those renovations, right?
yes,
And then you ask him for his insurance information and his driver's license and the car's registration, right?
yes,
And he says, it's my mama's car, right?
yes,
And you came to find out that when he was referring to mama, he was referring to Jolene Cagle, correct?
yes,
And that's who you found out the car was registered to, right?
yes,
And not only did that have a registration for Jolene Cagle in the vehicle that Mr. DeHart showed you, right?
yes,
But that's when you checked the vehicle using your equipment back in your cruiser later, that's what it showed who the vehicle was properly registered to, right?
yes,
And it was an active registration.
yes,
It wasn't expired, was it?
no,
The vehicle tags were not expired, were they?
not that I recall.
And then you got Mr. DeHart's driver's license, right?
Yes,
And his driver's license was not expired, was it?
no,
It was active.
yes,
And then he explained, it's my mama's car, and he started digging around for insurance cards, right?
yes,
And you told him, well, while you do that, I'm going to go on back to my cruiser, and I'll be back. Is that right?
yes,
And then you go back to your cruiser, correct?
yes,
And at that point in time, you start doing the things that I think you were talking about a moment ago. You get on your computer and you check Mr. DeHart's driver's license, right?
yes,
And the car registration, right?
yes,
And is that when you're checking to see whether or not the insurance information is in the state's database?
yes,
And just because that insurance information is not in the state's database, that doesn't mean the car has no insurance, right?
correct. That's why I was asking him to find proof of insurance. Typically on a traffic stop, if the proof of insurance comes back with the registration and they can't find an insurance card, I'm not gonna sign for no proof of insurance because there's a policy number, there's effective dates, all of that information is with the registration, so.
And so you did those things while you're back in your vehicle. Also, while you're back in your vehicle, do you, at that point in time, is that when you radioed to dispatch again?
Yes,
And what do you recall telling dispatch at that point?
I asked them to check him out of Knox and Sevier. When I asked for them to do that, they automatically check him locally.
All right. And at that point in time, do you radio ahead that you smell marijuana in the car?
I did not radio that, no.
You did not radio that. You didn't let dispatch know that, did you?
No.
At that point in time, while you are back in your vehicle after informing dispatch, you then use your personal cell phone to call Deputy McCallan, right?
Yes.
You did not use dispatch to ask another officer to come assist with the traffic stop, did you?
Deputy McCown was already on his way to assist me. He had informed me that via the radio. I just called him to give him more information on what my stop was and what I would need from him as a backup officer.
And is that why you called him on your personal phone at that point?
Yes, and may I add, I have a county-issued cell phone. My county-issued cell phone was not functioning at the time, is why I used my personal phone.
All right.
my supervisor for that a week prior to let him know.
And let me go back to this third interaction before you went back to your cruiser. At that point in time, while you're having this discussion with Mr. DeHart about Crumble Cookie and where he's been that day, where he's coming from, what he's doing, and he's responding to your questions and giving you that information, at any point in time, did you tell him you smelled marijuana? At any point in time, did you tell him, you know, I'm worried that you may be impaired? Did you tell him that? At any point in time, did you say, you know, can you step out of the vehicle for me and let's do some field sobrieties? And while you were there on the driver's side of the vehicle, your body camera video, and I believe it shows this on your dash cam as well, you actually shine your flashlight into the vehicle, is that right?
Yes.
And at that point in time, you didn't see any marijuana or drugs, did you? At that point in time, you didn't see any weapons, did you? And I believe you said on direct examination that Mr. DeHart was all over the place telling you stuff. Is that right?
Yes.
Okay. And I believe you described his speech as he was talking a lot and talking fast. Is that correct?
I would say rambling. would be a
Rambling?
better description,
Yeah. And he wasn't slurring his speech, was he?
yes. Not that I recall.
Okay. He wasn't talking slowly, was he?
Not that I recall.
And you'd agree marijuana is a depressant, isn't it?
Yes.
And you've conducted traffic stops where people have, you've come to find out later, were intoxicated on marijuana, right?
Yes.
When you go back to your patrol vehicle and you're having the phone conversation with, after the third interaction with Mr. DeHart, and you have the phone conversation with Deputy McCowan, is that when you tell him that you smelled marijuana?
Yes. I told Deputy McCowan.
You told Deputy McCowan that?
Yes.
And I believe you said this, but I want to make certain that my question is clear. You also said at that point in time, you didn't call into dispatch saying you smelled marijuana, right?
No, I did not call them in over the radio.
Now, we talked about this a moment ago. You were interviewed by the TBI about a week after February 8th of 2024, right?
Yes.
And that would have been February 15th of 2024.
Yes.
And during that interview, you had a lawyer present, right?
Yes.
And you were informed of your rights before you were interviewed, right?
Yes.
And you knew you had the right to remain silent and the right to have a lawyer present with you, correct?
Yes.
And you chose to be interviewed by the TBI, right?
Yes.
And to have counsel with you, right?
Yes.
And you were told by the TBI that if you didn't tell them the truth, that could be a separate crime, weren't you?
Yes.
And you told the TBI during that interview, quote, "I'll be 100% honest with you. When I walked up to the driver's side of the vehicle, I was so focused on watching him, watched his hands, watched his face. I was watching his reaction. I didn't smell anything out of the ordinary on the driver's side of the vehicle. It wasn't until I got to the passenger side of the vehicle that I noticed the odor of marijuana." Right?
Yes, that is what I said.
That's what you told them.
Yes.
And the TBI told you, part of that interview, that talking to them was the same thing as making a statement under oath, right?
Yes.
Now, during this interaction with Mr. DeHart, initially, what I'm going to call the third interaction, During that interaction with Mr. DeHart, where you're on the driver's side of the vehicle, you rested your hands just kind of casually on the car. Do you recall that?
I don't recall exactly when, but the video actually,
Yeah. If the video shows that, any reason to dispute that?
no.
Okay. And you let Mr. DeHart open up the glove box and start rummaging around in it, correct?
Yes,
And he was rummaging around in it, wasn't he?
yes,
He was pulling out all sorts of papers, weren't he? Wasn't he?
yes,
And all sorts of stuff from the glove box, right?
yes,
I think you described at one point he had like 10 different insurance cards, right?
yes.
They were all the same insurance company. They just went back all the way to like 2016 or something
Yeah.
like that.
Quite a long time.
Right. But you let him do that in the glove box while you're standing there, correct?
Yes,
At another point in time, you let him bend down and fish for his wallet that was in the floorboard, right?
I did, yes.
And he told you, my wallet's down here in the floor. Let me dig it up for you, correct?
I don't remember if he said that, but.
Something, yeah, the video accurately depicts it. Did he tell you something to the effect of, hey, my wallet's in the floorboard, I'm going to get it for you? Something to that effect?
I would have,
Okay.
honestly, I'd have to listen to the video again.
Okay. So irrespective of what you recall him saying, you do recall allowing him to bend over, reach into the floorboard, and get his wallet for you?
Yes, I watched him do that.
All right. And at no time did you ask him if he had any weapons, right?
No.
At no time did you ask him to keep his hands in your eye line eyesight, did you?
No. I was able to see his hands, so I didn't need to ask him to do that.
Even when he was rummaging around in the glove box?
Yes,
Even when his hands were down in the floorboard?
yes, I was watching his hands.
All right. And
You can see me actually take a step back in the video and lean over. I know that you can't see what I saw, but you can tell from my body cam that I moved backwards. That was so that I could see his hands when he was reaching for his ball.
okay. So you could see into the car and see his hands, right?
Yes,
Okay. And during this first interaction on the side of the road, and the second interaction on the side of the road, and the third interaction that occurred in the driveway, each time when you went back to your patrol vehicle, you turned your back on Mr. DeHart and just walked back to your vehicle, right?
yes,
And that total conversation, the third conversation with Mr. DeHart, where you're on the driver's side of the vehicle, that was about a 3-minute conversation. Do you recall that?
I believe so.
And then you go back to your patrol vehicle. You recall how long you were in your patrol vehicle before you approached Mr. DeHart again?
If I had to guess, less than 5 minutes. I'm not exactly sure how long it was.
You agree the time would be accurately reflected on the video, though?
Yes.
Right? And while you were in your patrol vehicle, did you also, while you were waiting for Deputy McCowan, do some things unrelated to Mr. DeHart specifically?
I checked the map, if that's what you're referring to.
You checked the map to see where another officer was?
Yes, in reference to this traffic stop. I did look at a traffic stop. You can see me skim through calls. I was looking for a traffic stop that I was on my way to when I stopped Mr. DeHart. There was another deputy that had made a stop that was making an arrest, and I was on my way to back her up when I stopped Mr. DeHart. So I did check that stop.
So you checked that stop, right?
Yes, to make sure that everything was okay there.
And one of the things that you were doing, though, is you were, while you were back in your patrol vehicle, you were giving some time for Deputy McCowan to arrive on the scene, right?
Yes, and also for Mr. DeHart to locate his insurance.
Sure, I understand that. But one of the reasons why I just said, one of the reasons why you were giving some additional time for Deputy McCowan to arrive on the scene, correct?
Yes.
Okay. And Give one moment, Your Honor. Before going and interacting with Mr. DeHart for the fourth time, you told Deputy McCowan you were code 4, correct?
That was the third time.
The third time,
Yes, the third approach, the driveway approach.
the driveway approach.
Yes,
You told Deputy McCowan specifically you were code 4?
yes, that was when he radioed and asked me if I needed to know.
That was part of the phone call,
That was part of the radio transmission on the third approach.
on the third approach. So this was prior, or that would have been prior to the phone call you had with Deputy McCowan
Yes.
while you were in
Yes,
your patrol vehicle?
correct.
All right. And you learned that there were no active investigations concerning Mr. DeHart, right?
Yes,
You learned there were no active warrants on him, right?
yes,
And at that time, while you're in the back of your vehicle, you didn't begin to write him a ticket, right?
yes.
You did not?
No, I did not.
You did not?
Yes,
And you weren't writing him a ticket for weaving in the road, were you?
no, not.
You weren't writing him a ticket for lack of proof of insurance, were you?
No, not at this time.
Okay. And at no point in time did you even start writing him a ticket or initiate writing him a ticket, is that right?
Correct.
Okay. And so after waiting in your patrol vehicle for roughly 3 minutes, is that fair?
If that's what's on the video, then yes,
Yeah.
that would be more accurate.
Yeah, if that's what's on the video, then that's what the video shows. In my notes, I have 3 minutes. Any
That-
reason to
yes.
dispute that?
That's, no, I agree with you, that's probably approximate.
All right. You and I both talk fast, and I'm going to try not to talk over you, okay? So let's talk about this fourth interaction with Mr. DeHart, okay?
Okay,
So you now, at this point in time, after about 3 minutes, you get out of your patrol vehicle and you approach Mr. DeHart's vehicle, this time on the passenger side of that vehicle.
yes,
And you approach him on the passenger side of that vehicle, and he rolls his window down for you, right?
yes,
And once again, at this point in time, he doesn't just crack it to talk to you, he takes it down all the way, right?
yes,
And at that point in time, you learn that he's on the phone with his grandmother, correct?
yes,
Mrs. Cagle.
yes,
And he's on the phone with her, still trying to dig up insurance information, right?
yes,
And at that point in time, you tell him, I'm not worried about the insurance, right?
yes,
And you tell him that you smell weed in the car, right?
yes,
And when you said weed, you meant marijuana, right?
yes.
And let's talk about that for a moment. You didn't have any training in the academy on smell of marijuana, did you?
No, field training,
Field training only. And when you say field training only, that it means just from out interacting with the public as an officer, right?
yes,
And you don't have any training to distinguish legal hemp or illegal cannabis, do you?
no,
And I believe when you and I talked about this at the preliminary hearing, you acknowledged that there's no way for you to distinguish between the smell of legal hemp and the smell of illegal cannabis, correct?
correct,
And so at the time you made this approach to the passenger side of the vehicle and you have this fourth interaction with Mr. DeHart, you still had his license and his registration, correct?
yes,
And at that point in time, you don't give them back to him, do you?
no,
You keep them.
I believe they were in my car,
They were still in your car.
I believe so, yes,
And if the video shows that this interaction between you and Mr. DeHart before Deputy McCowan arrives, this fourth interaction on the passenger side of the vehicle, was about 7.5 minutes long. Any reason to dispute that?
No, I agree.
And once again, the window's all the way down, and you can see completely into the vehicle, can't you?
Yes.
And at that point in time, you don't see anything that looks like contraband, do you?
No.
And you were looking into the vehicle because if you saw contraband, you knew that would give you another basis to search, right?
Correct.
And you ended up even having a discussion with Jolene Cagle, who was on the phone, right?
Yes.
And she heard you say, there's marijuana, there's weed in the car, right?
I believe I said I smelled it. I don't think I said.
You smelled it. Yes,
Yes.
I smelled it. Thanks for correcting me. And you repeatedly told Mr. DeHart you're not accusing him of smoking weed.
Correct.
You just tell him that you intend to search the car because you smell marijuana, right?
Yes.
And Ms. Cagle says no one's been smoking weed in that car, right?
Yes.
And at that point in time, you told Mr. DeHart, so when I smell the odor of marijuana, I have probable cause to search the vehicle, correct?
Yes.
And he says, why can't I refuse a search? You recall that?
Yes.
And you said, because I've got probable cause to search the vehicle because of the smell. You recall that?
Yes.
And I didn't say that you smoke weed. I said it smells like weed. I didn't say you did. Do you recall telling that to Mr. DeHart?
Yes.
And Mr. DeHart told you, I don't smoke weed. Right?
Yes.
And then there's a continued discussion between you and Mr. DeHart about you smell weed, and he says he doesn't smoke weed, and it goes on for several sentences between the two of you, correct? And then you say at one point in time, Kenny, I never accused you of smoking weed, right?
Yes.
And at that point in time, you still had not told him, I think you're DUI, right?
Correct.
At that point in time, you didn't say, I need you to get out of the car because we're going to do some field sobriety tests, okay? You didn't tell him that, did you?
Correct. No, I didn't.
At that point in time, you didn't tell him, hey, I'd like for you to step out of the car, period. You never said it like that, did you?
No.
You said, I smell weed, I have probable cause, I smell marijuana.
I believe I did say step out of the car several times without explaining why, but
Well, let's break that down, okay? Initially, you never told him to step out of the car before telling him you've got probable cause to search.
correct.
Okay. So initially you say, I have probable cause to search the vehicle. Step out of the vehicle, right?
Correct.
Okay. My point being, you never told him to step out of the vehicle because you want to do field sobriety testing or you want to pat him down, right?
Correct.
Jack, that's been asked and answered several times.
And now, at some point in time, Mr. DeHart gets off the phone with Jolene Cagle, right?
Yes.
And he calls another female, correct?
Yes.
And he calls this other female, and he asks her to tell you that he doesn't smoke weed. Do you recall that?
Yes.
And she tells you he doesn't smoke weed, correct?
Yes.
And then he asks this other female to come down to where he's pulled over, and you heard her say, I'm coming, right?
Yes.
And with the DUI stop, it's not unusual for someone else to come who can drive the car away, right?
Correct.
Someone who's unimpaired, correct?
Yes.
That way, someone who's unimpaired could drive the car away, as opposed to the vehicle being impounded and subjected to an inventory search, right?
Yes.
And so at that point in time, you knew someone else was coming to the scene, and it was this third female, correct?
Correct.
And if that person was unimpaired, they could have driven Mr. DeHart's car home if you had arrested him for DUI.
Well, I'm going to object at this point to speculation and relevance. None of this actually occurred. So I don't see how it's relevant to the determination as to whether or not the lawful seizure occurred in this case.
Well, then how is it relevant?
I'm going through the factors of what would occur with a DUI stop when you would get someone out of the car to perform field sobriety testing and then have a third party who's unimpaired drive the vehicle. And I'm just establishing that that was a potential scenario here, and in fact, there was a third party on the way to drive the vehicle.
It's irrelevant to the determination of whether or not this should be suppressed.
I'll move on, Your Honor. You didn't tell Mr. DeHart he needed to get out of the car for your own safety, did you? And Mr. DeHart told you that he was not going to consent to a search, right?
Yes.
He told you at that point, correct?
Correct.
And he told you that he was not going to get out of the car, correct?
Correct.
And he said, get a drug dog, right?
Correct.
And you told him a drug dog was not available, right?
Yes.
And I believe you also told him a drug dog can't smell weed.
Correct.
And at that point in time, and this is before still Deputy McCowan has arrived, this is in that several minute interaction on when you're still on the passenger side of the vehicle. You tell him if he's not going to get out of the car, so here's what's going to happen. If you don't step out of the car, we're going to have to drag you out of the car, and then we're going to take you to jail. You recall saying that?
Yes.
And so it was at that point in time that you threatened some sort of force as to Mr. DeHart, correct?
Yes.
That you were going to drag him out of the car.
Yes.
And you didn't say you said they. That we are going to drag you out of the car, correct?
Yes.
And so you said you either have to step out of the car or I can pull you out of the car, correct?
Yes.
And at that point in time, you planned to search the entire vehicle,
Wherever marijuana would be present.
which I believe you've said before could be any container in the vehicle, right?
Yes. Anywhere marijuana would reasonably be present.
And your plan was to search everywhere in the vehicle for that, correct? Now, at some point in time, Deputy McCowan arrives, correct?
Yes.
And when Deputy McCowan arrives, he also places his patrol vehicle, if I recall correctly, is it to the left or to the right of your vehicle?
To the left of my vehicle.
To the left of your vehicle. And he approaches the driver's side of Mr. DeHart's vehicle,
Yes.
correct? And at the time he approaches the driver's side of Mr. DeHart's vehicle, had you communicated to Deputy McCowan or to dispatch that you had pulled over Mr. DeHart and he was refusing to get out of the car?
Yes.
When did you do that?
Sometime within that 7-minute frame, shortly after Mr. DeHart and I began talking back and forth.
And so when Deputy McCowan arrives on the scene, he knows at that point you've got a situation where you've got an individual who's refusing to exit a vehicle, right?
Yes.
And as a result, when Deputy McCowan arrives, he immediately starts commanding Mr. DeHart, get out of the car.
Yes.
And when he arrives, does he already have his taser drawn?
I don't recall.
Whatever the video shows, it
Whatever the
shows.
video shows, yes, I have.
And about a little bit less than a minute after Deputy McCowan arrives, you move from the passenger side of the vehicle over to the driver's side of the vehicle. Is that correct?
Yes.
And you join Deputy McCowan on the driver's side of the vehicle,
Yes.
right? And at this point in time, do you recall whether or not Deputy McCowan had drawn his taser?
I don't believe so, whatever the video shows.
And you attempt to open Mr. DeHart's driver's side door, is that right?
Yes.
And it gets opened by about an inch and he pulls it closed, is that
Yes.
correct? He still has the window down at that point, correct?
Yes.
And you're eventually able to get the door open, is that right?
Yes, I believe when he shut the door, he locked it. I reached in to unlock it and then reopened it.
And then you reopen the door
Yes.
through the open window.
Yes.
And at that point in time, when the door is now open, is that when Deputy McCowan draws his taser?
I was in the middle of fighting with Mr. DeHart. I'm not sure exact, I believe the video would accurately represent, I believe he drew it as I was backing off, as I was backing out the door.
As you were backing out the door?
Yes.
All right, let me break that down a little bit, okay?
Okay.
Just make certain I understand. So, after you've got the car door open, and is that when you then make this approach inside the vehicle with
Yes.
Mr. DeHart?
Yes.
Okay, and at that point in time, and when you've described this, is that when you were having to reach over his belly to try to get the seatbelt off?
That's when we were testing, yes.
Yeah, what you described as tussling, right?
Yes.
And let me ask you about tussling a little bit. You're the one that initiated physical contact with Mr. DeHart, right?
Yes.
And at any time did he punch you?
I don't know that it was, as I described it, it was more of, I think he was pushing me away, pushing my hands away, pushing me away.
From the seatbelt?
Yes, from unbuckling.
And at that point in time, just given his size, were you sort of right up against him in the vehicle at that
Yes.
point in time? And just because the punching thing, I think you said, let me ask that again to make certain I got that right. When I asked you he wasn't punching you just a moment ago, did you say that you don't remember or you don't think he was?
I think she answered the question that she describes it as pushing.
So the basis of your objection?
The basis of the objection asked and answered, and I know he's asking that he doesn't recall the answer. And I guess if he wants to hear her answer, that's fine, but, I mean, it has been asked and answered.
It has been asked and answered, Mr. Johnson.
Yeah, but I think she said I don't recall, Judge, and I'm just trying to.
And that's the answer.
Yes, and so that if that's what her answer is, then I'm just going to refresh your recollection with her prior testimony.
I
And
think she said, I think she,
yeah.
part of her answer was it would be on the tape.
I believe you
Oh,
described
just
it.
read it to yourself. I'll ask you some
Oh,
questions.
okay, I'm ready.
Okay, good. Do you recall me asking you if he was punching you, and you said, "I don't believe so"?
I don't believe so, I would describe it as actively resisting, is what I said there.
Right. And so when you said a moment ago, "I don't recall," was your testimony preliminary hearing accurate? You don't believe he was punching you?
I don't believe he was punching me, like I said, it was more of a tussle or a struggle. I don't think that he, for lack of a better term, I don't think that he reared back and threw a haymaker at me. I mean, it was more of just pushing, and he may have hit me, I may have hit him, but it was more of pushing and fighting each other. Fighting away from him.
And there's not a lot of space in that vehicle,
No.
right? Okay. So after that interaction in the vehicle where you were trying to get Mr. DeHart's seatbelt off, at some point in time you come out of the vehicle, right?
Yes,
And at that point in time, do you recall that's when Deputy McCowan had the taser out?
yes,
And Mr. DeHart begged not to be pulled or tased? Do you recall that?
yes,
And he says, "Get your hands off me, please. Please put your hands off me, please, please." Do you recall that?
yes,
And he starts getting a phone call at that point. Do you recall that?
yes.
And he asks you if he can answer his phone, right?
I don't remember him asking me, but if that's on the video, then it's accurate.
All right. And if it's at 20 minutes, 22 seconds, and 20:22:06 in the video,
I do remember the phone ringing, I didn't
Yeah.
remember him asking me.
you don't remember him asking. If it's on the video, it's there.
Correct.
Do you remember at one point in time him saying, "Please stop, let me talk to my mama and my kids"?
If it's on the video, then it's accurate.
All right. No reason to dispute that he said that?
No, if it's on the video.
He kept calling you ma'am and Deputy McCowan sir?
Yes,
That interaction between you and Mr. DeHart, that first physical interaction, it lasted about 10 seconds, right?
yes,
As soon as you get out of the vehicle, how soon after that do you recall Deputy McCowan shot the taser at Mr. DeHart?
we both communicated with him a little bit more before. I don't know exactly how long, less than 30 seconds, probably less than 15 seconds. But we both communicated with him and informed him that if he didn't step out of the car, he was going to be tasing him.
Do you recall in your Garrity interview with the TBI, and do you know what I mean when I say Garrity interview?
Yes.
Do you recall in your Garrity interview with the TBI telling the TBI at that point you were attempting to de-escalate?
Yes,
What were you doing to de-escalate at that point?
informing him that he had an option to get out of the car so that he would not be tasing him. He was asking me to stop, not to tase him, and not to touch him, but in order for me not to do that, he was gonna have to step out of the vehicle. That was my de-escalation.
Did you tell Deputy McCowan, go ahead, hit him?
Yes.
And when you said that, you meant go ahead and shoot him with the taser?
Yes,
On your body cam, do you recall hearing Deputy McCowan while he had the taser pointed at Mr. DeHart, but before he tased Mr. DeHart, telling dispatch the situation was code 4?
yes. And I went over the radio, I'm not sure which, I believe Deputy McCowan's radio transmission picked up code 4. We both called out at the same time over the radio. I called out taser deployed, he called out code 4.
So you were calling out taser deployed, but he was calling out code 4.
Correct. You can hear me say taser deployed on video.
You testified on direct examination about the impact of tasers. You recall that?
Yes.
And I asked you some questions a little earlier in this examination about tasers. And let me, now that we're at the point in the chronology where the taser's being deployed to Mr. DeHart, let me ask you some questions about that.
Okay.
And is it your understanding that tasers work like a moment ago I said shot him with the taser. It's forced air projectiles, right?
Yes.
And it's forced air projectiles that are attached to a wire, a lead.
Yes.
And the goal is to shoot electricity into someone's body, right?
Yes.
And incapacitate them by disrupting their nervous system.
Yes.
And they can completely incapacitate you, right?
As far as not being able to move completely incapacitated, yes.
And they hurt.
Yes.
And I believe you testified at a prior hearing that you say that tasers hurt like hell. You recall that?
Yes. I believe that was not PDI interview.
Actually, that was both your first and your second preliminary hearing testimony.
Yes.
And we'll get to the TBI interview in a moment when you talk about tasers. So even a partial cycle of a taser hurts, right?
Yes.
And during the, well, let me ask you this. I believe you testified on a direct examination that the first deployment of the taser was, to use your word, you said ineffective. Is that right?
Yes.
And you said it was ineffective because the probes did not connect.
Possibly. I'm not sure that would be a possible explanation. Probes did not connect, or that he was able to swap when it did connect, he was able to swap away and pull it out. One of the two.
So that was the first tasing, and then there was, in total, you would say 3 effective tasings of Mr. DeHart, right?
Yes.
And if I understood your testimony correctly and the video correctly, the second full tasing is when you came in contact with the wire. Is that
Yes.
right? And so you got a partial cycle of that tase deployment?
Yes.
And you got a partial cycle of it, not with the leads into your body, right?
Yes.
Just by you touching the wire, correct?
Yes.
And it affected you.
Yes.
It hurt you.
Yes.
And I believe you testified before that a taser makes you feel like your muscles are trying to jump out of your body.
Yes.
And that was the effect that partial cycle had on you, correct?
Yes.
At no point in time did Kenneth DeHart say, hit me with a taser, did he? Well, I'm asking you that because in your TBI interview, do you recall telling the TBI, and I said, look, man, if you don't get out of the car, you're going to get tased. And he said, hit me. I'm not getting out of this car. Hit me, hit me. And I looked at Greg and I said, hit him. Is that how things went down?
No. Not according to the video. At that point, I had not reviewed any of the video, and it was after the most traumatic incident of my life. So I've made mistakes, and I had forgotten a lot, and I was doing my best, giving them my best recollection that occurred.
And I understand. And this was a week after a horrible experience that you had been through, right?
Yes.
And you had to go to the hospital and get emergency medical care, right?
This was the day after Deputy McCown
and an emotional time for you.
Yes,
Understandably so, right?
yes.
Correct? And at no point in time, though, did your lawyer say, we need to hold off doing this interview, did he?
Nope.
At no point in time did you say, we don't need to do this interview with the TBI, do we?
No.
You went ahead and you went forward with that interview with the TBI, right?
Yes. In order to be transparent and do my job.
And you said you had not reviewed the video at that point in time, correct?
Yes.
The video is not going to capture smells, is it?
No.
And so you were relating at that point in time the best of your recollection, but the best of your recollection that had not been visually refreshed from the video, correct?
Yes.
But you were also relating the best of your recollection as it was concerning what you had smelled, right?
I also articulated, you can see on the video, I articulated on a phone call prior to my passenger side approach that I smelled the odor of marijuana.
Yep, I understand, but I'm talking about what you were articulating to TBI at the time without looking at the video. You were letting them know, under oath, in effect, when you had smelled the marijuana.
I don't believe any interview with TBI is under oath unless I've missed something that they are not, can't charge them with perjury for lying to TBI that I'm aware of. This isn't a federal court system.
Well, I'm not saying it's a federal court system.
You're saying they're under oath.
Well, you can be charged with a crime for lying to TBI. And she's admitted, the witness has said, yes, that was her understanding going into this interview. I asked her what her understanding was.
I'm objecting to him saying she was under oath in her interview with TBI.
Can I respond? I said in effect. I said in effect under oath.
That's not before the court. I do not have the information from the interview. I do not have the circumstances under which it was conducted. I do not have before me an oath or a recording, so that is not going to be characterized that way. You've asked the question of her understanding, but don't characterize it.
I won't characterize it that way, Judge. The testimony that you've already given about what your understanding was of that interview with the TBI, is that accurate?
Yes.
All right. So, after you were, during the second full-on taser deployment, the one that, and I'll call the second one, for argument's sake here, I'll call the second one the one that you're saying was effective, okay? So the third taser deployment, but the second effective one, all right?
Yes.
Okay, so after the second effective one where you were impacted by the taser, as soon as the 5-second deployment of the taser stopped, you backed away, correct?
Yes.
And you backed away and you said, I've been tased,
Yes.
right? And it impacted you, correct?
Yes.
Even after the tasing was done.
I wouldn't say after the tasing was done, that it was affecting me. It was affecting me during the tasing.
You recall telling the TBI that you were disoriented a little bit after that?
Yes. I would use a different word now, but yes, that is the word I used.
You would use a different word now, but the word you used was disoriented, correct?
Yes.
It was disorienting while it was going on, correct?
I was aware of what was happening. I was aware I was being tased.
Okay.
Disorienting in the manner that I was not able to continue to perform my job duties while I was being tased.
Now, after the second, what you would call effective tasing, where you got tased, and the third, that's really the third tasing of Mr. DeHart. There then is a fourth tasing of Mr. DeHart, right?
Yes.
And
that would be our third effective.
third effective,
Yes.
fourth in total.
Deployment, yes.
Fourth deployment, third effective tasing. And there was no instructions or commands given to Mr. DeHart between the third and the fourth tasing, right?
No,
Once you were out of the way, the fourth taser was deployed, right?
I believe so, yes.
And I believe you testified that it was in the middle of that third effective tasing, fourth total deployment, that when the gunshot started.
Yes,
And you said the first shot hit you,
yes,
and you believe the second and third shots hit Deputy McCowan.
I believe so. I'm not sure exactly which order of the shots, but yes.
Just one moment to look at my notes, Your Honor. Here's, I'm gonna, we'll mark this as exhibit 3 for identification. Can you take a look at that for me, please? Do you recognize that document?
Yes, can I keep this one?
Absolutely.
Okay.
And this is the certification test that you took in the academy to utilize a taser, is that correct?
Yes.
Or at
I
least-
believe this is the full test, but yes.
Yeah, it's one page of it. It's not the complete test, right?
Yes,
The complete test would be in your training records, is that right?
yes.
Have you looked back at your training records?
No, I've not looked at anything with the taser.
All right. But so you're just going from memory right now from the academy, correct?
Yes.
And so, obviously it's got the name up at the top, Shelby Eggers, correct? And Blount County Sheriff's Office. And so if you'll go to, on that page, question 4. And if you missed a question on this test, the person grading it would write an X on the answer, is that right? And if you got the answer right, it just has your circle, is that correct?
Yes.
Okay. So one of the questions that you had to ask was, or answer after training was, as with any use of force, the longer the CEW, you see that?
Yes.
In CEW, conducted energy weapons. Is that right?
Yes.
Was that what you were told in training a taser is called?
Yes.
A conducted energy weapon? And as with any use of force, the longer the CEW exposure, the greater the risk of potential cumulative physiological, metabolic, and other effects, right?
Yes.
And that was getting at if you're tasing someone multiple times, correct?
Yes.
The greater that risk is, right?
Yes.
And you got that answer correct.
Yes.
I'll move Exhibit 3 into evidence, Your Honor.
Object to relevance. How is the fact that greater exposure could lead to physiological, metabolic, or other effects relevant to this suppression
goes to the issue of what her training was and what her understanding was of the force that is to be deployed with a taser and the dangers with multiple deployments in rapid succession. And whether or not that was reasonable under the circumstances, under the Graham test that she was trained on.
And I would also ask that under the rule of completeness, if the court is going to admit, the entire test, and not just this portion.
I think based upon the pleadings and what has been purported to be part of the defense's argument, I think find it relevant for the purposes of what they're asking, and based upon her identification of this document and rule of completeness, will accept the entire document.
So I'll go ahead now, Judge, and based on that, I have
I don't know what this is,
these are the entirety of the training records the state provided to us in
I'm going
discovery.
to reserve on that to give General Desmond an opportunity to review what's on the document before.
Yeah. And for General Desmond, and I'll represent to the court.
I guess I would inquire, is this the complete training records of Deputy Eggers, all of her training records?
These are all of her training records on the flash drive that I've handed to you, as well as what I've just printed out here.
So this, everything that's on here is right here.
No, everything, the complete training records have not been printed out because it's extensive, and so I've got them on the flash drive.
I'm going to table that and give you all an opportunity here in just a moment. I'll take a recess and let you review the document.
And I have reviewed her training records, Your Honor, previously. I just don't,
Right.
other than being told what's on this, I'm just assuming that's what's
Yeah.
on here because Mr. Johnson tells me that's what's on here. I guess I would, assuming that's correct, that this is her training records, I would pose an objection as to the relevance of submitting her physical documented training records into this hearing.
But you asked for the rule of completeness,
I asked for a rule of completeness regarding the TASER certification that he
TASER
asked her about.
certification, so not the entire training.
Not
records.
her entire training records, her TASER certification test that he questioned her about.
That's fine. I mean, what we could do,
You have that as a separate document printed out?
can we late file that as just a separate document, Judge?
Well, no, because I'm going to consider, and so let's take 5, and you all figure out what that is, and we'll be in recess for 5 to
All
10
right.
minutes. Then.
Yeah, let me get you the page. So there's a subfolder within the rules called grant activities. Yeah, you can have it. There you go. You gave it to me. No, I'll give it back.
is 2. Somebody is still full and somebody has 2. Emma, do you have more? This is at 2. Do you want to leave it? I have the opposite.
Main seating come in order.
Did we work through that issue?
We did, Your Honor.
Okay.
And-
What do I have as the next exhibit?
So Judge, I think what we're going to do, that is Exhibit 3, I believe, by agreement, Exhibit 4 is going to be the complete taser training examination given to Deputy Eggers when she was in the academy.
That's an agreed exhibit.
That is the complete record.
All right, so I received this for.
And if we could, if I could withdraw Exhibit 4, and Eggers, I'm going to give you Exhibit 4. Previously at Exhibit 3, I was showing you one of the pages in Exhibit 4, is that right?
Yes.
And if you look at that exhibit, I believe I was showing you the third page of that exhibit,
Yes.
page 1 of the Part 1 conducted energy weapon test, right?
Yes.
Okay. And I asked you, I believe, about question 4 on page 1, correct?
Page 1 of that test, yes.
Of that test, right. And the longer the conducted energy weapon exposure, the greater risk of potential cumulative physiologic, metabolic, and other effects, right?
Yes.
Okay. And if you look at question 7, also in that test, it says the further CEW exposure is away from the heart and the fewer CEW cycles applied, the greater the safety margin for the CEW affecting the heart, right?
Yes.
And now we'll go to page 2 of 4. Question 9. Taser CEWs are serious weapons and to be treated as such at all times, correct?
Yes.
And then question 10, when deploying probes to the front of a person's body, the CEW should generally be aimed at the waist area to split the belt line, right?
Yes.
Now, going back to where Mr. DeHart was tased, where the wires were impacting his body, it was the shoulder area, was it not, of his left side?
I'm not exactly sure what it impacted him. Somewhere in his upper body, but I'm not exactly sure what.
Somewhere in his upper body?
Yes.
The video will show it where the impact was, right?
Yes, if you can tell on the video. then
Okay. And so if the video shows that the impact was in the upper shoulder area of his body, any reason to dispute that now?
No.
Okay. And if you go to question 15, it says the term currently used by taser training to describe the incapacitating effects of a CEW, it says neuromuscular incapacitation, right?
Yes.
Is that where you got that phrase?
Yes.
And if we go to page 3, it defines what CEW is, and it's a conducted energy weapon at number 18.
Yes.
And let's go down to question 23. a CEW application on a person can cause physiological or metabolic effects, including but not limited to changes in, and then there's a number of options after that, right? And you circled all of the above, right? And you got that answer right, correct? And so it can cause changes in blood chemistry, right?
Yes.
It can cause changes in heart rate and rhythm, right?
Yes.
It can cause changes in blood pressure, right?
Yes.
Changes in respiration,
Yes.
changes in adrenaline and stress hormones, right?
Yes.
If we go to page 4, question 25. When considering the use of force, when reasonable, give subjects a reasonable opportunity to comply before force is used or repeated. Is that correct?
Yes,
And
correct.
so that's what you were trained, right?
Yes.
And then that's answer A, and then answer C, immediately cease any force once the subject is under control, right?
Yes.
And you circled E, A and C. Was that the correct answer?
Yes.
Okay. And then let's go to question 26. An officer should avoid repeated or continuous CEW exposures unless necessary to counter an immediate threat. Right?
Yes.
And you circled true.
Yes.
And that was the right answer.
Yes.
So let me now go back to the 3 tasings as to Mr. DeHart. The 3 effective tasings.
Yes.
Okay? 4 deployments, 3 effective tasings.
Yes.
Between the second tasing where you got tased and the third tasing, Mr. DeHart was not given an opportunity to comply, was he?
Yes.
Was he told? I think we just you testified a moment ago.
I did not speak and say, get out of the car again, but he had been told an ample amount of times to get out of the car.
Well, I understand. I'm focusing on the time between that second tasing where you got tased and the immediate third tasing, okay?
Yes. No, I
That-
did not tell him again.
You did not tell him again. And neither did Deputy McKellar.
I don't believe so.
And at that point in time, other than not getting out of his car, Mr. DeHart had not he had not done anything to show that he was an immediate threat. He had not displayed a weapon to you, had he?
No.
He had not cursed at you or told you he was going to hit or hurt you, had he?
No, but he had actively resisted me.
He had resisted you when you went into his vehicle and you laid hands on him, correct?
Yes.
Other than that, and once again, I'm going to go now after you had already done that, okay? And I'm going to the tasings, okay? So, in between the first and second tasings, after that first full-on contact, in between the first full-on contact and the second full-on contact, you didn't go into the car and he didn't actively resist you, did he?
The first full-on contact and the second full-on contact. No.
No. And so between the first and the second, he was not an immediate threat at that point.
Correct, because he was incapacitated by a taser.
Well, he was incapacitated with the first one, and then for that time period between the first and the second, he was not an immediate threat at that point, right?
No.
And then with the second full-on tasing, that's when you engaged in some additional physical interaction with Mr. DeHart, right?
Yes.
And when you engage in that additional physical interaction with Mr. DeHart, at the time you went into the car to touch him and to take the seatbelt off, he was already being tased, right?
Yes.
He was incapacitated.
I object that this has been asked and answered on multiple occasions. We have gone through all 3 cycles of tasing 3 or 4 times now, and she has answered the questions relative to
response to that objection?
My response to that objection is it's not asked and answered with respect to the issue of her training and whether or not Mr. DeHart was an immediate threat. And her training was specific that you don't continue to tase if the person is not an immediate threat. And so I'm eliciting questions concerning each tasing and the immediate threat issue.
And I'm going to find that that is asked and answered multiple times about the tasings, and that it is not relevant to the inquiry that we're here for today and what has been pled as part of these motions.
All right? Have a moment, Your Honor.
Yes.
No further questions at this time.
Are you ready?
No, Your Honor.
This witness step down. Your next deputy Anderson. Thank you. Call your next witness, General.
That is the state's proof of the suppression motion.
Proof on behalf of the defendant.
Our proof are the exhibits that either came in by stipulation or the testimony that we elicited from Deputy Akers.
Yes, and by that you refer to, again, as Exhibit 1, which is the 2 dash cams and the 2 body cams,
Yes, Your Honor.
as well as the other exhibits.
Yes, Your Honor.
Okay, all right, thank you. All right, then I'll hear you.
Your Honor, we have briefed this thoroughly. We've supplemented that briefing.
You have, and I have read and reread and pulled cases and looked at all of the issues. But yes, I did want to give you an opportunity, even though it has been well litigated. I wanted to give you an opportunity for if you chose to do so.
I'm just going to hit just a few brief highlights, Judge, and I know we have briefed this extensively. When analyzing an excessive force claim under the Graham case, the court does have to conduct an analysis of reasonableness under the circumstances. And we did provide the court with several cases from the U.S. Court of Appeals from the Sixth Circuit on analyzing excessive force cases. The state, in their response, dealt with some of those cases, but one case that they did not mention at all, and is one that we relied on fairly extensively, is the Eldridge case. And for example, we discussed that this is an example of how substantive our briefing is. In our memorandum of support at page 102, we go into some detail about the Eldridge case, and as the court is aware from looking at that case, that was a DUI stop, and it was a traffic stop, and the person refused to get out of the vehicle, and the officer believed that there was some sort of impairment. The person was, I think, slurring their speech, if I recall the facts of the case correctly, and lethargic. Unlike the situation here, I don't believe there was a situation where the officer physically went in and was laying hands on Mr. Eldridge, but there was a tasing that occurred in that particular case. And the U.S. Court of Appeals for the Sixth Circuit held in that case, and they discuss in the King case that we cited, also in that same portion of our memorandum from the Sixth Circuit, the line of Sixth Circuit authority on tasing individuals who are in parked vehicles or refusing to get out of parked vehicles. And so we respectfully submit to the court that on this particular issue, and I'm not going to go through all of our briefing on all the other issues with the traffic stop. The court has that, and just for the record, I'll say I'm not intending to waive or some sort of, in a way, abandon those arguments by not going into them now.
And I will note that for the record that, again, all the positions
so I'm just going to really just hit this issue right now, Judge. And so what the court has before it concerning the excessive force issue is that the training here was that a taser is a weapon and that it can cause death, it can cause serious injury, there are after effects with it, and that they were trained, as the court noted when I was going through that in that last exhibit with Deputy Eggers. Officers in Blount County, and Deputy Eggers specifically, were trained on you only continue to use the taser if the person presents an immediate threat. And Deputy Eggers testified that Mr. DeHart was not an immediate threat. That was her testimony here. And they were tasing him after she tried to get him out of the car, and she was unable to do so. And she describes this as a tussle, and she also had difficulty just because of his girth, getting around him and getting the seatbelt undone. And then when she gets out of the vehicle, shortly thereafter, the first deployment of the taser occurs. And their training is that after each deployment of the taser, you give an opportunity to de-escalate, and then an opportunity for other measures to be employed, if need be, before tasing again. And you only tase, and that's the reason why I went through that laboriously, and that document's now in evidence, of only if the person is an imminent threat do you continue to tase again. And their training was you don't continue to tase in rapid succession because it can have physiological impact, nervous system impact, and even impact with their adrenaline response. And so I respectfully submit to the court that was, at that point, an illegal seizure of Mr. DeHart. It was inconsistent with their training. And that Mr. DeHart was subjected to unnecessary force and force that would be a violation of the Fourth Amendment and the Tennessee Constitution, and that the exclusionary rule should apply. We've briefed for the court all the policy reasons concerning the exclusionary rule, and I respectfully submit to the court that when you apply those policy reasons that the Tennessee Supreme Court has stated are the reason for the existence of the exclusionary rule, that there should not be a carve-out under the Tennessee Constitution or the U.S. Constitution for an excessive force claim. The policy and procedures on use of force that are now in evidence has in that exhibit at subsection G, and I believe this is page 4. It talks about when feasible based on the circumstances, deputies will use disengagements, and those include area containment, surveillance, waiting on a subject, summoning reinforcements, and or calling in special units. You're to do all of that before you engage in use of force. And here, Deputy Eggers testified that on February 8th of 2024, it was a training day, and all of the patrol officers were out that evening. There were more law enforcement officers available out on patrol than some other nights. And those other measures in the use of force policy were not employed here. And as the court knows from taking a look at Graham cases and the Graham analysis of whether or not there has been excessive force, the issue becomes, what were the officers trained? Were the officers acting consistent with that training? And that's part of the analysis as to whether or not, from that officer's perspective, at the time, it was reasonable force under the circumstances. And The state has raised this issue of, under Rule 47, whether or not we have been specific enough in what we want to suppress. One of the issues in this case was, in part, there's a whole lot of stuff and we didn't have a 12D notice. We now have a 12D notice, and that has narrowed the scope of what we are talking about here today. With respect to what we want suppressed, I'll be very clear, and we said this when we raised this issue with the Sessions Court on remand. What we seek to suppress is any evidence post that excessive force, which means any evidence that Mr. DeHart shot either one of these officers, any evidence resulting from these shootings. We believe that that is, if the exclusionary rule applies, that is the appropriate analysis under Wong Sung from the U.S. Supreme Court. And so I just wanted to clarify that. To the extent the state has raised that, I wanted to clarify for the court and for the record that now under the constrained Rule 12D notice that we have, or now that we have the 12D notice that we have, I want to make it very clear for the record what we're seeking to suppress. Thank you, Mike.
Thank you, Your Honor. Mr. DeHart has filed a civil lawsuit alleging that law enforcement Mr. DeHart has filed a civil lawsuit alleging that law enforcement used excessive force on February 8th, 2024. That's not what this courtroom is here for. This is not the civil lawsuit. This is the criminal prosecution of Mr. DeHart, wherein the defendant has filed a motion to suppress evidence. So the state should be looking at the standards and the authority applicable to criminal prosecutions and motions to suppress evidence, not civil lawsuits relative to excessive use of force. Now, I certainly disagree with Mr. Johnson's characterization that excessive force was even used in this case. The officers put hands on Mr. DeHart because Mr. DeHart refused dozens of requests or directions to get out of the vehicle. The officers tased Mr. DeHart because he resisted the officers when they put hands on Mr. DeHart to try to remove him from the vehicle. They tased him a second time because the first time did not work. They tased him a third time because the second time did not work. It was his refusal to comply with lawful instructions that led to each and every step of force that was instituted against him. So it will respectfully be the position of the state of Tennessee that no excessive force was utilized by law enforcement officers based on the totality of the circumstances of what was reasonable in this specific factual scenario based on the actions and decisions made by Mr. DeHart. However, even if the court were to conclude that the force used was excessive, there is zero authority, as Mr. Johnson, I believe, will concede, that the exclusionary rule applies in this particular legal theory. It just does not exist in the state of Tennessee. I understand why Mr. Johnson wants to preserve that issue. I understand why he may want to argue it at a higher court. But as far as today's proceeding at the trial court level, there is simply no authority to the concept of excluding evidence based on excessive use of force under these particular scenarios. So respectfully, the state will submit that that just does not have a legal basis to succeed at this point in time. State, I know Mr. Johnson did not, and the state's not going to either go into great detail as to the traffic stop. The video speaks to itself, and as to the interaction between Deputy Eggers and Mr. DeHart, the video speaks for itself. But once again, the state finds it necessary to point out that defense counsel is respectfully speaking out of both sides of their mouth. On one scenario, they want evidence to suppressed because the traffic stop was unnecessarily prolonged. It took too long for Deputy Eggers to do what she did. The state disagrees with that. But on the other side, the defense counsel would say she should have waited. She should have de-escalated by bringing in more deputies and bringing in, additional manpower. So the evidence should be suppressed because it took too long, and the evidence should be suppressed because she didn't wait longer. And respectfully, the state just feels that argument does not carry water. And when we're talking about the length of the traffic stop, the state just wants to point out very, very briefly, this was not a long traffic stop. From the second Deputy Eggers activated her blue lights at 8:02 and 15 seconds to when Mr. DeHart shot Deputy McCowan, 20 minutes and 49 seconds elapsed. That is, in the light absolutely most favorable to the defendant, the absolute maximum length of time this traffic stop occurred. The state would submit the traffic stop was not prolonged anywhere due to the actions of Deputy Eggers anywhere near that long. If you take the time that, because the defendant stopped in the middle of the road and pulled in the driveway where Deputy Eggers actually approached him in the driveway, you have to cut about 2.5 minutes off of that interaction. And then you have to cut another 7 minutes after the defendant is actively refusing to get out of the car, because it is not Deputy Eggers that is prolonging the traffic stop at that point in time. It is Mr. DeHart that is prolonging the traffic stop at that time by his refusal to comply with lawful orders. So in reality, if you take out the time where Mr. DeHart is refusing to exit the vehicle to the time Deputy Eggers actually makes contact, the traffic stop is only 14 minutes and 1 second. So respectfully, the state is going to submit that this is not a prolonged traffic stop. Deputy Eggers had more than reasonable suspicion, clearly had probable cause to effect a traffic stop. Her actions with Mr. DeHart were appropriate and in furtherance of the investigation and within the scope of the traffic stop she was conducting. She articulated specific facts that expanded the scope of that investigation to include a DUI investigation and a search of the vehicle based on her specific facts regarding the mannerisms of the defendant, the speech of the defendant, the driving behavior of the defendant, the odor of marijuana. All of that is used to make a conclusion under the totality of the circumstances that her actions were reasonable. The scope of that traffic stop was properly expanded, and she had reasonable suspicion for the DUI investigation and probable cause to search the vehicle based on that articulation. It was not unreasonably prolonged. The state respectfully submits that the use of force demonstrated by Deputy Eggers and Deputy McCowan was incredibly reasonable under the circumstances, and that things digressed and were exacerbated by the choices and decisions of the defendant, Mr. DeHart, and that this motion to suppress should be denied.
Final word, Ms. Johnson?
Very briefly, as to two sides out of my mouth, I do have to respond to that. The issue as to whether or not there should have been delay and there should have been de-escalation and there should have been, for example, under the Blount County's own policy, either waiting the defendant out or calling in additional officers, for example, that is if you get to the point of the continued detention at that point is still lawful. So what we briefed before is that when you look at every step of the analysis, one factor that the court has to look at is there some sort of reasonable suspicion to continue to detain? That's that argument that the state's conflating the two issues there. And so I just want to clear that up. I'm not talking out of both sides of my mouth. Finally, with this issue concerning there is no authority on the applicability of the exclusionary rule in Tennessee or from the U.S. Supreme Court to a violation of the Fourth Amendment of the Tennessee Constitution via excessive force. There's also no law that says that it does not apply. And it would not make sense for there to be a narrow carve-out of the exclusionary rule just for that type of Fourth Amendment violation. And just because there is the ability to bring a 42 U.S.C. Section 1983 claim for an excessive force claim doesn't mean, as a policy reason, it should be carved out. A 1983 claim can be brought for any constitutional violation, not just excessive force claims. It can be brought for any Fourth Amendment violation, not just excessive force claims. In fact, that speaks to the issue of there's not a carve-out for remedies for a violation of the Fourth Amendment in the Tennessee Constitution. For all those reasons, Your Honor, we ask the court to suppress the evidence that we have articulated.
Thank you all.
Thank you.